Today we're going to talk about trial testimony and documents. One of the biggest changes I've seen in the decades of reading appellate records is how many trial lawyers today take the trial testimony just like they took a deposition. The testimony frequently consists of, let me show you Exhibit 7. Can you identify it? What's the date? Who's it from? Who's it to? What topic does it concern? Now let's put it on the screen. Please read it to the jury. And then they go on to the next document. It's okay to take a deposition that way. It's a horrible way to present trial testimony. Try to use as few documents as possible at trial. Simply ask the witnesses the questions. If it's not disputed, you don't necessarily have to read the document that repeats the witness's testimony. If it is disputed, simply say something like, do we have a document that confirms that testimony? Yes, we do. And is that document Exhibit 7? Yes, it is. And move on. You can always come back and redirect or recross to go into great detail if the lawyer on the other side is still dumb enough to pursue it. But when you load up the record with just days and days of testimony that does nothing but reads documents to the jury, you're putting them to sleep, you're overwhelming them. You do want the documents and evidence, but get them pre-admitted. And then on appeal, they can constitute sufficient evidence to support the verdict, even if they were never discussed in trial. Maybe some lawyers don't know that, and they feel like I have to talk about the document, but you really don't. It's in the record. So please think about every document that you use, and is it absolutely necessary? See you next week.